Well, hello, David. We are back again with an update on PUA and sort of the status of PUA at this point. But hello, everyone.
Well, hello, David.
I am Ray Gertkin with the Reno Office of Nevada Legal Services.
Yes, and I'm David Olshan. I'm with Nevada Legal Services. And it's not Ocean, it's Olshan.
That didn't help. We do apologize. We are trying the live transcription. So hopefully that helps if you are hearing impaired or watching this without sound. But as I said, we will be talking about PUA and writs of mandamus today. Again, we kind of realized the last live stream we didn't really talk about many of the updates to the Pandemic Unemployment Assistance Program that had come from numerous changes to the Department of Labor guidance to the PUA program. So we're going to go through a little bit of that first and then go over again the petition for writ of mandamus in the event that you are still one of the many people that has not gotten benefits or your benefits stopped and you haven't gotten a hearing yet. All right, so as I mentioned, the Department of Labor issued their guidance in a unemployment insurance program letter 16-20, and they have now changed it or updated it 5 times. These changes initially clarified additional questions that people had while implementing the program, but later on, they also included the updates from the Continued Assistance to Unemployed Workers Act, that was part of the Consolidated Appropriations Act that was signed in December of 2020. All right, change 1. David, do you want to talk about change 1?
Yes, change 1, it's a blast from the past. First of all, what was made abundantly clear early on is that your base period for calculating the benefit under PUA was based on 2019, based on the self-employment income or any other income from 2019. If you had no income and you had a COVID-related reason for being unemployed, they used the minimum benefit amount, which was $181. So we see a lot of people who qualify for $181. The most you can receive is $469. But initially, for the first benefit year, they used 2019 wages. What they also did is this was trying to help people. The Employment Security Division, DETR, was supposed to backdate it to the first date of unemployment related to COVID. Here in Nevada, I've said it, we've said it several times. It did allow January 28th, but it was converted here in Nevada to February 2nd. They did allow the backdate back to that February 2nd date, but very few people were out of work because of COVID on February 2nd. The real date of PUA benefits for a lot of people, for most people, is March 12th. And so that's what change 1 said. You have to backdate it to the first date of being unemployed as it relates to COVID. There were some other sort of issues. If you if you live in California but work in Nevada, this is a Nevada claim. A lot of the sort of law regarding regular unemployment applied to PUA. And so I think that's what the Department of Labor was scrambling with early on under the CARES Act, is trying to figure out how to disperse the money under the CARES Act and comply with the CARES Act law, which was kind of evolving. And we should say early on, the idea from Congress was to get these benefits from the idled worker from the government into the idled worker's hand. And so they allowed for self-attestation. They allowed for these easy ways to qualify for benefits. And unfortunately, this program was victimized by a lot of people who were fraudulently obtaining those benefits. And that the subsequent sort of Consolidated Appropriations Act and American Recovery Plan tried to address that fraud, and they did it in a very cumbersome, clumsy way.
Yes, and we'll talk about the distinction. We're going to have a couple of distinctions about the documentation requirements because, as David mentioned, there was self-attestation in the beginning for PUA benefits. The only documentation you would need to supply to substantiate anything was an increase in the weekly benefit amount, as David mentioned, but that has all changed. You now need to substantiate that you were in fact self-employed from the beginning, but we'll get into that when we talk about change 4. And now it doesn't want to go forward. The one other thing about change 2, changes 2 and 3 are pretty short and minor, but I did just want to mention one thing about change 2 is that we've had occasional questions like, if I was unemployed before coronavirus, but now I can't find a job, am I eligible for PUA? The answer is no. Your lack of employment has to be directly related to the coronavirus. So your termination, you're being laid off, you're not being able to engage in your business, whatever it is, the reason you're not actually the termination or the ending of your employment has to be because of the coronavirus. So if you were, say, laid off from a job in January, and it, was just because they were downsizing because of a, historic lack of customers or something, and it had nothing to do with the fact that the pandemic was already starting, then you're not eligible for PUA, even if you can't find a job now.
There's a subtle distinction here too, and that is there has to be this relationship to COVID, and it doesn't necessarily mean you need a job at the time of the shutdown. You could be taking care of school-age kids and they can't go to school, and that's related to COVID, but it doesn't mean you need a job. So you do need that connection to COVID. It doesn't necessarily mean you need a job at the time of the shutdown.
Right, but you need to be in one of those reasons, and not being able to find a job now,
right, exactly,
is not one of those accepted reasons. Alone, let's say that. All right, but the biggest change was change 4. Change 4 did a lot of things because it implemented the Consolidated Appropriations Act. Part of that is what's called the Continued Assistance for Unemployed Workers Act, or the Continued Assistance Act is what the shorthand for it. And what one of the provisions in change 4 did is require new substantiation of self-employment or employment. So, and really, this is really more geared towards targeted for self-employment, but it does apply to any employment. So now you have to show that you actually had a job that was then terminated because of coronavirus. So we're not talking, and this is where we get into the distinction, and we're going to talk about documentation requirements in multiple ways. Because we're only talking about the requirement to establish that you actually had a business or were working at the time, essentially that coronavirus was the reason you weren't working. So the documentation, as David discussed earlier, to substantiate a greater weekly benefit amount could be enough to satisfy this claim. So if you wanted more than the minimum benefit amount, more than the $181, you likely have already submitted tax forms because the benefit year again was 2019 or 2020 if you're dealing with this now. So you probably already submitted your 2019 tax return back last year. You probably already submitted things showing that your wages or your earnings were more than would substantiate, would result in just the minimum weekly benefit amount. If that's the case, you're probably okay. Most of that can apply. But if you didn't submit any documentation and we're just relying on the minimum weekly benefit amount, you are now required to substantiate your employment, self-employment, in order to qualify for pandemic unemployment assistance. So this requirement came out, with the law that was signed in December 2020, but it applies to all weeks of eligibility. So it applies to all of the weeks that you essentially claimed in 2020. issue is moving forward, you are now required to supply this documentation within 21 days upon request. And there are provisions that say that they're supposed to give you written notice and the time frame in which you're supposed to supply this information. 48 hours is not in compliance with the law. You are supposed to get 21 days in which to do this. And then if you ask for additional time with good cause, they can actually extend that time period. But essentially, you are required now to substantiate that you had employment or self-employment or a business or whatever it was back in the early part of 2020. So February, March 2020.
Can I just make a couple points?
Yeah.
First of all, this doesn't do anything to combat fraud. So what it does is it really excludes the people at sort of the bottom of the barrel, people who are day laborers, who babysit, who don't get W-2s, who don't get receipts, who get paid in cash. And they are not, they have a tough time negotiating the system to begin with and providing this documentation. So it really excludes the day laborer, the people who kind of like work from hand to mouth. And it simply doesn't combat the fraud because these are individuals, we know they're individuals, they just don't have the documentation to support what they're saying. So it's really, again, Congress not really realizing what they're doing and providing this hurdle that trips up a lot of the most needy people and excludes them from this program.
Right. One thing I will say is that if you filed your tax returns and included a Schedule C for your self-employment, that is good documentation though. As are signed statements. Now this does say signed affidavits. In Nevada, you can do an affidavit by declaration under penalty of perjury. I know that that is a difficult thing for people, especially people who have already submitted these statements, but they are supposed to be essentially affidavits, but statements from the people that you are going to work for with their name and contact information included. But some of the other documentation can be if you did have a business license, if you have a business receipts, invoices, or ledgers, anything that's business documentation. But I think for in that situation, David, that you were talking about, signed statements are probably going to be the only thing you can get. And certainly it's not going to be an affidavit that's actually signed in the presence of a notary. So I would just make sure that if you can include a declaration under penalty of perjury, but just, I would do the best you can. And then this also includes the proof of planned. So like if you, this is a situation that many people face, that they started a business or had planned on a business right before the coronavirus hit, and so couldn't actually do much as part of their business. This has happened to multiple people that we've represented. Then you can do the same thing. You can prove the commencement of your business by submitting the same documentation. With, different things like written business plans, lease agreements, if you're going to rent space, statements or some other beginnings of the business itself. But just remember that this applies to all of the claims moving forward, but it also applies to all of the previous claims. The one caveat is if you don't submit the substantiation and you have been receiving benefits, from, you were one of the lucky ones that actually got benefits, they cannot collect that money back from you simply because you didn't provide this documentation. But if you haven't gotten benefits or you're continuing to file claims in 2021, you have to provide this documentation. Otherwise, you potentially are ineligible and will not be getting PUA. One of the other things that Change 4 did was require ID verification, which everyone knows and everyone is dealing with now, the ID Me verification process. But David, do you want to go through the verification requirements and anything that's happening as far as ID Me is concerned?
I don't know what the specific requirements. I would think that you're going to include a copy of your driver's license, a state issued ID, along with a social security card with the names matching, and with the social security number matching the application that you've submitted to the Employment Security Division, make sure those are right. And people who have ready access to that and can scan documents and upload those without much trials or tribulations, this process is pretty easy. For people who don't have a state-issued ID, I guess they're using facial recognition software or things like that. Also, if you don't get it exactly right, you're excluded from the system for weeks on end. So it's clearly not working, not really a very useful program either. I think 20 states are using it. And if they have this much trouble, it's obviously not a good application to use. Simply providing a copy of your driver's license with your social security card or a W-2 or your tax forms, that could be sufficient to identify people. But of course, the Employment Security Division isn't doing that. They're using this convoluted, defective software, and it's harming people because you're not going to get benefits going forward.
Well, and it is in the actual change 4, it says that there's a specific program that states are encouraged to use, but if they don't use that one, there are others. So right. It is pretty much required that there be some sort of electronic app verification of people's identity. So, this is technically required in order to continue filing claims. And I know that, people are frustrated, even if you do have the documentation, and you are taking the video selfie for the facial recognition, because I think it's a video selfie, not just a picture, then, there's really, what's your recourse? This is required. If you have problems with ID.me, ESD isn't going to be able to help you out. People are being encouraged to contact ID.me support. They do have like FAQs and technical assistance, but they also have a support request that you can submit online at the website that I have up on the slide. But it is required, and if you don't get verified, it is possible that you, like David said, cannot file your claims.
Right. 2002, 2003, we had Real ID. It was recently implemented here in Nevada in 2020. Real ID is real, safe, and if you have a state-issued driver's license that complies with Real ID, that should really be enough. And if you have to supply a lease or a utility bill or something like that to match up the address, this all could be very, very easy if somebody just put 5 minutes of thought into it. And how DMV is able to process everyone in the state of Nevada with the Real ID requirements and not have these year-long waits kind of demonstrates a good state agency and a bad state agency.
Yes, it is unfortunate because so far we haven't really come up with much to do about this ID.me situation. Obviously, if the problem gets fixed, they should let you backdate your claims if you were unable to actually file a claim. So that is a potential problem for the future. That
we have this controversy, like is the Nevada ESD as bad as other states? Well, we know with ID.me it is, because 20 other states, including California, have this program, and it was promoted by the Department of Labor. So it's like, well, maybe they're all incompetent.
That's certainly possible. So I guess that's solidarity. Don't feel like you're alone in this.
Yay.
Although that's completely unhelpful. All right. Then finally, change 5. Now remember, the substantiation requirement is for proof that you were actually working. You can still self-certify that your termination of working, that the reason you were not able to continue working was due to the coronavirus. So they should not be requiring you to substantiate that your employment ended because of the coronavirus. There is a self-certification form that was included in the Department of Labor regulations because it also included these new additional eligibility COVID-related reasons. So self-certification should still be required or be all that's necessary just to establish that you're out of work due to COVID, but you still then have to establish that you were actually in work before COVID, and that's the documentation requirement. Don't know if that makes it clearer or not, but that's basically the standard for documentation requirements. But Change 5 did introduce 3 additional COVID-related reasons. One of these clarifies that if you were refusing to go to work because of a unsafe work environment, you now have essentially good cause for refusing that work if it was deemed unsafe. And that was basically not complying with state health and safety codes regarding coronavirus, social distancing, wearing masks, that whole thing. This isn't a COVID-related basis for eligibility, though. They really did make the distinction that it was really only if you were previously unemployed getting benefits and then refusing a job because they didn't comply with COVID restrictions.
Right, this is the PUA is a resource of last resort. So you're not eligible for state unemployment because you left work because of your refusal to accept work because it was unsafe. You're not eligible for regular unemployment. And the Department of Labor said, yeah, then you would be eligible for PUA. But you still need that PUA COVID-related reason for being idled, for being out of work.
Right. And, as we've discussed in previous videos, that could include that your employment at the time coronavirus happened was unsafe. There have been successful decisions that, you're quitting your job because of COVID could be a good reason to establish eligibility, but that is sort of a separate question than what they're addressing here, which is refusing an offer of work once you've already been idled. But the other two, the last one, I'm not sure I understand why it was necessary, but the middle one is if for people in the education system, if there was an issue with volatility in the work schedule, then, somebody could be eligible for PUA only if, though, they did not have a reasonable assurance of returning to work. So
Right.
if you were somehow working in the school system, but didn't have guaranteed continued employment because you didn't know whether it was going to be hybrid model, in-person model, whatever it was, you could potentially have a basis to apply for PUA, but only if, you're basically essentially idled, that there was no chance you were going back or no reasonable assurance. And then finally, that you had hours reduced or laid off as a direct result of COVID-19. I feel like that was a reason from the beginning, so I'm not sure the distinction here.
I don't know either, but I think it's just based on, you still have a job, but your hours are so reduced that you qualify for benefits. And so but it was there already.
Yeah, I feel like that was there. It's also just a part of Nevada regulations, having your hours reduced below the benefit amount would result in unemployment eligibility. So I guess this just makes it clear that yes, if your hours are reduced, you could potentially be eligible for PUA. And then, everybody knows when they submit the claims, they have to select their COVID-related reason for eligibility. This change makes clear that you're supposed to be able to select multiple and that your reason can change as the weeks go on.
And you could select no for a particular week. That was in the regulation. So that
I wouldn't suggest doing that.
I know. It's like
because unemployment benefits is a week-to-week benefit system. Right. You have to be eligible every single week that you file a claim, because if you're not eligible for 1 week, then you don't get paid for that week, but then you could be eligible for the next week. So just make sure that you're continuing all of these eligibility requirements. Why we're stressing the documentation requirements so heavily is that it's a week-to-week thing. So, you need to get that document information in so that you can continue to be eligible. Otherwise, every week you apply, you could be ineligible if you don't supply that information. All right. Now we're going to start getting into a little bit of what we discussed in our last live stream, which was petitions for writs of mandamus. But obviously, David, we're still seeing a lot of issues with ESD.
Yes. It was an article in the Nevada Independent about Nevada doesn't allow for direct deposit of unemployment benefits. They only have paper check and the EBT card. That is true. California has the same sort of situation. It is probably safer to have direct deposit. It, to me, is if it's going to a local bank, you're going to reduce the fraud. You're going to reduce a lot of the problems when you don't have like a Bank of America electronic benefit card. But yeah, that was one of the issues. Some people should just get the paper check sent to them. Unfortunately, then you have to, no, you can take a picture. I don't know what you can do for online banking because I don't do it, but
Yeah, you
sometimes
just take a picture of the front and back of the check. It's actually,
right.
There are limits though of the amount of the check in some circumstances. So if you get a large backdated check, back pay check, you might not be able to mobile deposit those, but for a lot of people, the weekly checks may be okay.
Right. And the other thing is having your benefit card frozen. So, right. That clearly is illegal. And right. Yes, we do allow for glitches and problems with technology and banks. But if it gets to be too long, then it's possibly a constitutional violation because they need to get you those benefits and they can't say, oh, the software is broken. So you're going to go 60 days without your benefits.
And I also just want to make clear because when this has obviously happened to people that we've been dealing with. And the one problem I see is that this is ESD's problem, not necessarily Bank of America's. So at the end of the day, I think it would be, we are looking at a due process violation on ESD's part if you're not able to access your benefits because Bank of America says that your card is frozen, you're not eligible, you weren't verified, ESD never told us to reactivate your account or whatever the reason is. I think it really is ESD's responsibility to provide you these benefits in the easiest way that you can access them. So I would probably be looking at suing ESD over Bank of America.
And they, I wouldn't necessarily trust the bank, but in the article in the Nevada Independent, Bank of America basically threw ESD under the bus. I mean, they said, yes, we warned them against this. We told them it wasn't the right way to do it, but they did it anyway. So, yes.
Yeah, I'm certainly not saying Bank of America is not in some way involved in the wrongdoings here, but I just think the recourse is likely going to be against ESD. Which brings us to petitions for writs of mandamus. We know that a lot of PUA hearings are happening. They are getting scheduled. And with those hearings getting scheduled, there is also a prompt decision requirement that they're supposed to issue in 80% of appeals, a decision within 45 days.
Right. Just below 7 weeks.
Right. So we do know that things are moving right now, but in the event you are not one of the lucky ones that is a part of that, and you've kind of gone into the black hole that is the ESD claim system, we are going to just kind of quickly go through our form petitions for writ of mandamus one more time. Before we do that, just remember, if you do get an overpayment notice, if you don't have a good legal argument that you don't owe the overpayment, there is still a possibility to waive that overpayment. And one of the other things that the Continued Assistance Act made clear was that PUA also has an overpayment waiver process where you can request waiver of PUA or UI. And again, the standard is basically if it's not based on fraud, you're without fault, and recovery would be against equity and good conscience are the three sort of pillars of overpayment waivers.
And if you look on the website, information for claimants on ESD's website, they say if you apply for regular unemployment and get both regular unemployment and PUA, that's fraud. So yeah, if you have two systems, it takes you years to decide. I think you're just asking for people to apply for both. And it really isn't fraud. You need the intent to commit fraud. Right. And you don't, if they give you the money, it's like their fault, not your fault.
No, I 100% agree. I think that's ridiculous. One of the things that you even noted from change one that I didn't include was that they were actually required to automatically switch people to PUA from UI if they were not eligible for UI. So I think the fact that they didn't do that and they were forcing people to essentially apply for both systems, they can't then claim that that was based on fraud.
Right.
So that would be my argument. Anyway. All right. Okay, so writs of mandamus. Again, the legal basis, David, do you want to go through the legal basis for mandamus?
Sure. So when the Department of Employment Training and Rehabilitation, the Employment Security Division, are supposed to decide whether you qualify for PUA, or after they deny you, hold a hearing, and they do that, they wait too long. And really the standard is by regulation 14 days, but the constitutional standard to deny due process is 7 weeks. So if you've been waiting more than 7 weeks to get a hearing or to get some decision on your PUA application, there's the opportunity to file a writ. A writ is available when you have no adequate remedy at law. And here, because the state agency hasn't done anything, has delayed your application for more than 7 weeks, or delayed a hearing more than 7 weeks, you can ask the district court to force the Employment Security Division to hold a hearing or disperse those benefits.
All right, and we do still have the forms for Washoe County and Clark County up. I know I said I was going to get the other ones up. I did, they're almost done. So hopefully after this, but we'll go ahead and just go through one more time.
Let me tell you, Ray, there was somebody from New Jersey who used our form. So
oh, well, there you go.
There you go. The beauty of the internet.
Yeah, we'll go ahead and go through one more time. This is just the petition for Clark County. Washoe is very similar, but there are some like minor quirks. So, you know, just they're not something we're going to address, but just be aware that some formatting differences exist. The substance of all of these is exactly the same.
And let me just note right at the beginning, if you look through this form, there's very few blanks. So it's pretty easy to fill out. And if people are daunted, or people are afraid to venture into this area, don't be, because it's real easy to fill out these forms. It's not so easy to get relief or get your benefits, but it's pretty easy to fill out these forms.
Right. And as we mentioned in our last video, it is very repetitive, but it's repetitive for a reason. I mean, as David mentioned, really, those are the only few fill in the blanks essentially that exist.
Right. You just want to repeat over and over again how long you've been waiting.
Right. But in the beginning, you just need to enter your name where it says petitioner. You are the petitioner. And then again, as you know, we said, the date you applied, the date you were denied, if that date exists, and then how long it's been since you've either had your benefits or a hearing. And then it goes through, like David explained, the legal basis for mandamus. And again, we've got that all just in there for you, so that you can just, again, go through and really highlight the facts. Again, the date you applied, the date you were denied, the date you requested a hearing, how long it's been since you've gotten benefits, you know, multiple times. Again, we've put in the legal arguments for you, but essentially that, as David explained, it's been over 7 weeks. That's a denial of due process in order to receive a state benefit. We go through the CARES Act, you know, the issuance of the emergency directive, and just essentially, again, that you submitted an application, how long it's been, when you appealed if you did, and how long it's been since you've done that. Again, how long it's been. That's sort of the key, is that, you know, once those 7 weeks are up, you know, you can file this, but in most people's cases, it's probably going to be way more than 7 weeks at this point. Again, we have additional legal bases for the petition, and then the next fill in the blank is just when you applied, how long it's been, and then your requested relief is that you get your benefits or hearing.
And let me say, there's a filing fee. In Clark County, it's $270. You can ask for a fee waiver. You may get the fee waiver, you may not get the fee waiver. But if you go forward with this, before you file, you're going to mail this writ off to the Attorney General's office and to the Employment Security Division. So it's possible you may not even get to file it because the court denies your fee waiver, but you're going to get the Employment Security Division to at least look at your writ and say, maybe we should address this. So there is some benefit in just simply filling this out and filing it. The judge most likely won't take an active interest, but if you let them know that you're trying to do something about it, sometimes that's all that's needed is to get a hearing.
Right. As you can see, we just have, you need to mail it when you file it to the Attorney General's office in ESD. And so as David indicated, you know, regardless of what happens next, you have served them with it. So they will be on notice. And, you know, really the point of this is just to say, hey, I'm still here. You know, you say that you're scheduling hearings and helping people, but I'm not one of them.
All right.
So
people should know too that there is, if you're complaining to one of your congressmen, senators, there's a private line to Alyssa Caporado. So if you can get to her because you have power or influence, we should be able to get to her as well. And this is one of the ways we can get to her by filing these writs.
But again, just to make clear, we can't guarantee any outcome.
No.
We have had very, very varied success and failure with these. You know, failure in the sense that the judge doesn't take any faster action than ESD. I don't think we've had any straight up denied. But, you know, the court process is not a fast one. It is not like you're going to file this and get your benefits the next day. Now, granted, you know, things could start moving if this does trigger ESD to look at your claim and actually take action. But, you know, we're not aware of that many judges and courts that understand the petition process and promptly issue the writs of mandamus. So just keep that in mind that we cannot guarantee any speed, timeframe, or outcome.
Right. Just imagine if you're filing this writ with the Employment Security Division. So judges, court clerks, they are oftentimes worse than people at the Employment Security Division. So just keep a perspective. This may not go anywhere, but at least you're doing something about it.
And that, I mean, if that's any comfort for that, certainly, you know, I understand that, you know, sometimes just being able, feeling like you can do something to change your situation is
Right.
as powerful. All right, but that pretty much concludes our presentation. There was one comment where can you sign up for this? All of these forms that we've been talking about are on our website, nlslaw.net. If you go up to find oh my gosh, I don't know what the menu option is, but it's in our unemployment section. If you find the unemployment section, you'll be able to find these forms. Actually, you know what? Let me see. David, if you have any other thoughts, I'll see if I can pull that website up right now.
Sure. If you go to our website too, you can email us and we can send you the forms.
I forgot to put the PUA written now email address up there. I apologize.
It's on the last one. If you go to
on the instructions, right? Yeah.
Yeah.
Okay. All right. I have the website up. So. Yeah. All right. So if you go to Know Your Rights, Work and Employment, click on that. Oh, that didn't share, did it? Nope. Let me try this again. All right, sorry.
Oh, there you go.
Now we're sharing. So sorry, if you go to Know Your Rights, there's a work and employment section. Sorry. It doesn't say unemployment, it says work and employment. If you click on that, the first thing that comes up is unemployment benefits and then the forms. So they're right there on top. They have instructions. If you go, as David indicated, if you go to the instructions, we do kind of try to do it as step-by-step as we can for everybody. We talk about the fee waivers. If there are electronic filing or forms, we do include links to those, as well as the PUA written now at gmail.com email address. If you have questions while you're filing this, really these are questions for the process of filing. Feel free to email us and we will try to address them. We cannot give you any legal advice. This is not an application for our assistance. This is simply you're filing this form on your own and something is, you're unsure that you're filing it correctly. Give us an email. On our website though, there are, you can, if you think that you qualify for our services, you can submit an online intake to see if we might be able to help you.
And sometimes these are empty words, but these are your benefits. This is your court system. This is your employment security division. So demand what's yours. And if you do, maybe good things will happen. It's just unfortunate that the squeaky wheel gets the grease, but this is kind of what we're saying. This writ is a squeaky wheel.
Right. And just again, I can't stress a squeaky wheel that we don't know how squeaky it will end up being. So just keep that in mind as we're going through.
In the middle of the forest, maybe nobody hears it.
Yeah. All right. Well, I hope we didn't go through everything too quickly, but again, this will live on our YouTube page, Nevada Legal Services Now. Please, feel free to watch it as many times as you need. And then, yeah, let us know if you have any questions as you're going through the process. But I think that'll do it, David, unless there's anything else you think we can address.
Not at this point.
All right. Well, thank you for joining us again for this live stream regarding PUA benefits. We will be doing these every two Thursdays a month. So the second and fourth Thursday of every month, we will have a live stream on a different topic. Of course, depending on what happens, we could be addressing unemployment benefits, ESD, and PUA again. But do join us at noon on the second and fourth Thursdays of every month for David and I and other Nevada Legal Services attorneys to address some legal issues. Thank you, David.
Thank you, Ray.
All right, then we will see everybody later.
That's a wrap.